Hello and welcome back to Drama Investigator. Saucy. Okay, so this lawsuit just keeps getting worse and worse. Tati Westbrook, for those of you who don't know, is suing a popular drama channel without a crystal ball, whose real name is Katie. Tati is suing Katie for making false statements about her husband, trying to find out information about her family members, and for making countless videos about Tati, where Tati alleges that Katie lied and defamed her. Now, Tati's lawyer is not playing games at all. Tati has allegedly spent over $100,000 on yet another lawsuit against Katie, so it's all getting very expensive. Basically, Katie is now being called out for destructing evidence by deleting the videos and tweets that she made about Tati. So there's been 2 lawsuits against Katie made now. The initial one was for defaming Tati, and then the current one recently made against her was a declaration in motion for an order to preserve evidence. So we briefly touched on this new lawsuit yesterday, but since then I've found the full lawsuit against Katie online, all the legal papers covering her order to preserve evidence, which Katie has received and has not done. So let's get into this juicy lawsuit. It states, within a half hour of the complaint being filed on Friday, October the 30th, 2020, I sent a copy of the complaint and a preservation of evidence notice to defendant Katie Joy Paulson via email. The preservation of evidence notice expressly instructed defendants to preserve published content related to my clients, including without limitation, social media posts, comments on social media posts and videos, live chats, direct messages, instant messages, emails, phone messages, and text messages. The notice further requested that defendants preserve as evidence any court related to or regarding my clients in any way that you posted to or published on any internet platform, including but not limited to Instagram, Twitter, and YouTube. Finally, the notice informed defendants that their failure to preserve such documents and evidence may result in evidentiary or other sanctions being imposed against them. Attached as Exhibit A is a true and correct copy of the October 30th, 2020 email to defendant Paulson. And here we can see that email that was sent to Katie. The lawsuit then continues. At 7:23 am on Saturday, October 31st, 2020, I received an email from defendant Paulson's Minnesota attorney referencing this lawsuit and requesting that all further communications be directed to him. Attached as Exhibit B is a true and correct copy of the email received on October 31st, 2020. And here we can see that email that was sent to her. The lawsuit continues. Defendants, after receiving the evidence preservation notice and complaint, began deleting their videos and other online content related to my clients, including specific content referenced in the complaint from various online platforms such as YouTube, Facebook, and Twitter. Attached as Exhibit C are examples and evidence of defendants' deletions that I personally acquired between October 30th and the date of the execution of this declaration. These mass deletions began immediately after I sent the preservation of evidence notice and complaint to defendant Paulson on October 30th, 2020. This conduct has continued as of the date of filing this declaration. And here we can see screenshots of those deleted videos and also deleted tweets. And here we can see screenshots of tweets of Tati's fans that are talking about Katie deleting lots of evidence. And then in this saucy since deleted tweet, Without a Crystal Ball had tweeted, lawsuits discovered by Without a Crystal Ball last year, along with criminal convictions for James Westbrook, I've referenced in the lawsuit as a pattern of fraudulent and criminal activity. We were tipped off about the suit by a source and asked us to break the story. Juicy. The lawsuit continues. In fact, my office was in the process of documenting tweets on defendant Without a Crystal Ball's Twitter page and witnessed the disappearance of tweets related to my clients. In addition to actually witnessing some of these deletions, we also observed tweets by others calling attention to defendants' sudden deletion of content on their various social media platforms. Then at some point over the Halloween weekend, defendant Without a Crystal Ball's entire Twitter account was deactivated. By November the 2nd, 2020, the Twitter account had been reactivated. However, at least 37 tweets have been deleted. Similarly, by November the 2nd, 2020, defendant Paulson had deleted every tweet prior to September 13th, 2019 on her personal Twitter account, Katie Joy YouTube, which has been active since 2015. Once tweets are deleted, they are permanently lost, along with any analytic data or other information that could be gleaned from such online postings, including the number of people who saw the tweets, how many people spread it through retweets, and the identity of the people who publish potentially information. Likewise, defendants also deleted Facebook posts and comments in YouTube videos after receiving the evidence preservation notice and complaint. Like Twitter, once Facebook posts or comments are deleted, they cannot be recovered, and any analytic data or other information that could be gleaned from such comments and postings is forever lost. Similarly, the deletion of YouTube videos permanently removes all chats, comments, and other information related to the videos, including the number of views and defendants' own comments containing additional defamatory statements. Such information cannot be recovered even even if the video itself is recovered. I have personal experience with the way YouTube channels work. My personal experience derives from the fact that I currently represent multiple YouTube channels, including a YouTube channel that in 2019 was the largest and most successful YouTube content provider in the world, and my representation involves issues with regard to the management of the analytics related to my clients' pages. I also have personal experience managing the technical aspects of a YouTube page for a family member and have personally interacted with YouTube with regards to deleting and privatizing videos that have been uploaded to YouTube for a specific page and channel. When a video is uploaded to a channel on the YouTube platform, YouTube immediately starts to collect data on users' interactions with that video. Some interactions occur by way of allowing users to leave comments on the video page. Other interactions such as views and activity related to views are also tracked. This tracking is called analytics. The analytics for each video uploaded to a YouTube channel are unique to that particular video and include a number of views, the number of times viewers remain viewing a video, the geographic location of certain viewers, and how viewers accessed said video. For a monetized channel, the analytics also will include revenue information with regard to how much money a particular video has generated for the channel owner. Once a video is uploaded to a channel on the YouTube platform, the channel owner can make the video public or private or can delete it. YouTube will maintain all comments and analytics for all uploads to a channel, regardless of whether they are public or private. However, once a video is deleted from the YouTube platform, all such comments and analytics are destroyed and permanently lost for that particular video. I also have a personal Twitter page and I'm familiar with the workings of Twitter as a result of my managing the same and as a result of litigating cases involving Twitter and efforts to retrieve deleted information and other litigation matters. Twitter allows an account holder to post tweets, i.e. statements, on the own Twitter page and on the pages of other users, which tweets also will be accessible through that particular account holder's own page. Like YouTube, Twitter maintains analytics on every tweet that a user posts. These analytics track impressions, meaning the amount of users that have interacted with the posted tweet. The analytics also includes data such as how many times users engage with a particular tweet by pressing on it, or the picture of the tweet's author to obtain more information about the author and its Twitter page, the number of likes users placed on a particular post, and the number of times a post has been retweeted, i.e. reposted, by other users, including the identity of the users who retweeted said post. Once a post or tweet is deleted, all the analytics for the tweet are destroyed and cannot be subsequently retrieved. I declare under penalty of perjury, under the laws of the United States of America, that the foregoing is true and correct. Further on in the lawsuit it states, the court found that an evidence preservation order was appropriate, even though a litigation hold had been issued, because there was evidence that potentially relevant electronic evidence had been deleted by defendant's agents. There was evidence that the deleted data was unrecoverable, such that irreparable harm in the form of lost evidence is likely to result ... if no evidence preservation order is entered, and the preservation order would only preserve the status quo, such that the defendant would be essentially unaffected by it. There exist significant risks to the continuing existence and maintenance of the integrity of the relevant evidence if no preservation order is issued. Because defendants already have destroyed evidence after being put on notice of their duty to preserve, the first factor in the balancing test weighs heavily in favour of the preservation order. In Curta Inc., evidence of data deletion alone was sufficient for the first factor to weigh in favour of ordering preservation of evidence. Here, defendants' actions demonstrate an even more egregious and blatant disregard of their discovery obligations than occurred in Curta Inc. As soon as defendants received a copy of the complaint and the preservation of evidence notice, they began deleting the online content related to plaintiffs, including deleting videos, comments, and other posts. In addition, as demonstrated below, the online evidence deleted by defendants is relevant to plaintiffs' claim because such evidence 1. Shows the content and context of the statements made by defendants. 2. Shows how defendants' audience perceived the statements as statements of fact rather than opinions. 3. Provides IP addresses and other identifying information of potential witnesses and potential additional defendants. 4. Shows how many views the defamatory statements had, which is relevant to damage. 5. Shows the length of time videos were viewed, which is relevant to damages. And 5. Shows how many times and where defendants' defamatory statements were further disseminated by others, which is relevant to damages and identification of additional potential defendants. For example, when a video is uploaded to a channel on the YouTube platform, YouTube immediately starts to collect data on users' interactions with that video. Some interactions occur by way of allowing users to leave comments on the video page. Other interactions such as views and activity related to views also are tracked. This tracking is called analytics. The analytics for each video uploaded to a YouTube channel are unique to that particular video and include the number of views, the length of time viewers remain viewing the video, the geographic location of certain viewers, and how viewers viewers access said video. For a monetized channel, the analytics also will include revenue information with regard to how much money a particular video has generated for the channel owner. Once a video is uploaded to a channel on the YouTube platform, the channel owner can make a video public or private or can delete it. YouTube will maintain all comments and analytics for all uploaded videos on a channel regardless of whether they are public or private. However, once a video is deleted from the YouTube platform, all such comments and analytics are destroyed and permanently lost for that particular video. Further on, it states, defendants' actions in immediately deleting relevant evidence despite being advised of their duty to preserve such evidence demonstrate the likelihood defendants will continue to delete relevant evidence. For the foregoing reasons, if no preservation order is issued, there are significant risks to the continued existence and maintenance of the integrity of relevant evidence. Plaintiffs are likely to incur irreparable harm if no evidence preservation order is issued, because the relevant evidence defendants have destroyed and likely will continue to destroy is necessary to providing plaintiff's claim, including the perception of content viewers, amount of damages, and identification of potential witnesses and defendants. The second factor of the balancing test weighs heavily in favour of a preservation order. As explained above, the deletion of online posts, tweets, and videos not only deletes the post videos, tweets themselves, but also permanently deletes the analytics related to such online content. Even if videos or original post tweets can be recovered through screenshots or video downloads, the valuable analytics evidence related to such content cannot be recovered. In other words, the deletion of the videos, tweets, and other posts from the platforms upon which they previously were housed already has caused the irrecoverable destruction of the analytics of and comments on said videos, tweets, and posts. Therefore, like in Curta Inc., irreparable harm in the form of lost evidence is likely to result ... if no evidence preservation order is entered. A preservation of evidence order will not prejudice defendants and would retain the status quo. The third factor also weighs in favour of a preservation order because such an order does not create any financial or other burden on defendants to maintain such evidence. First, the deletion of evidence clearly was done in direct response to the commencement of this litigation and not as part of any routine actions or activities of defendants. Second, there are no physical, spatial, or financial burdens on defendants if they are ordered not to delete additional relevant evidence. Defendants are the only ones with the capability to maintain the relevant evidence. Like the circumstances in Curta Inc., a preservation of evidence order merely would preserve the status quo. It would not impact any additional burdens onto defendants to maintain the relevant evidence. Therefore, like in Curta Inc., defendants essentially would be unaffected by an order preserving evidence. For the foregoing reasons, the three-factor balancing test weighs heavily in favour of an evidence preservation order against defendants. Accordingly, plaintiffs respectfully request that this court grant this motion and issue an order requiring defendants to preserve relevant evidence, including without limitation all social media and online posts, videos, comments, and all communications such as text messages, direct messages, and emails relating to, regarding, or referencing any of the plaintiffs. Saucy. So what are your thoughts on all this drama? Let me know in the comments.